Welcome to Balch's Consumer Finance Compass, where we will navigate the complex regulatory sphere that is consumer finance. My name is Jason Tompkins, and I'm a member of the Consumer Finance Compliance and Defense Practice. Today we'll explore Nabozny v. Optio Solutions, a recent decision from the Seventh Circuit Court of Appeals. In Nabozny, the issue was one of standing. You may recall that standing is a necessary ingredient to bringing a case in federal court. And one requirement of standing is that the plaintiff suffer an injury. The decision from the Seventh Circuit that we're discussing today, a debt collector used a vendor to populate, print, and mail a letter to the debtor. And the plaintiff here, Mrs. Nabozny. She claimed that by disclosing her information to that letter vendor, that the debt collector had violated the Fair Debt Collection Practices Act, which generally prohibits, subject to certain exceptions that don't apply here, the disclosure of personal information about a debt to any third party. The lower courts have reached differing decisions about whether this is enough to be an injury for purposes of federal court standing. But the Seventh Circuit becomes the third court of appeals after the 11th and the 10th to hold that it is not enough for standing. The premise that underlies all of these appellate decisions is that Congress cannot simply enact an injury into existence. In other words, violation of a statute is not in and of itself an injury. There must be some consequence. When that consequence is monetary or physical harm, standing is easy. But when the consequence is more intangible, the question becomes a little bit more complex. In that situation, the injury has to bear some close relationship to a traditional harm that's been recognized by American courts. Nabozny argued here that common law principle was one of invasion of privacy. Now, invasion of privacy actually has 4 different variations. The first is intrusion upon seclusion. You may remember from our first episode about Optio, that's what the court analogized an unwanted text message to. The second form is appropriation of name or likeness. The third is publicity of one's private life. And the final is publicity that places one in a false light. The third one, which is commonly called public disclosure of private facts, is the one that was potentially relevant to the Seventh Circuit's decision. But in looking at what American courts have done with that particular common law tort, the Court of Appeals concluded that publicity requires disclosure to the public at large or to a subset of people where it's likely to become public. So either a great number of people, so that it's likely to become more public, or a particular type of person, such as a journalist, who you know may then write an article about that situation. The court concluded here that a letter vendor was entirely different. A communication to a single intermediary vendor who the debt collector was using for the purpose of sending a letter not to anyone in the public, but to the debtor herself, was not the same as public dissemination of private facts. Debt collectors and other companies use vendors for a wide variety of activities. In this case, is a good reminder that while plaintiffs may argue that those business practices could violate the terms of a statute, it doesn't necessarily lead to a federal lawsuit or to liability for doing so. So let's keep in mind these tips when faced with litigation under consumer finance statutes. The first is, don't stop asking questions just because a violation occurred. You must ask that second question. Did an injury occur? Because a violation in and of itself may not be enough. The second step is to look at the specific type of harm alleged. Does it bear some resemblance to a traditional injury that courts in America would address? And the final point is to reevaluate standing throughout the life of the case. In Nabozny, the challenge was a facial challenge. The defendant argued that Nabozny's complaint did not even allege enough of an injury to invoke federal court's jurisdiction. But there are also factual challenges that may arise based on discovery in the case. You may learn that there was no physical or monetary damage. Instead, the plaintiff is only claiming intangible harm, in which case you must undergo this analysis of a common law analog. And standing is something that cannot be waived, does not have to be preserved, and can be raised on appeal for the first time. Thank you for joining us on Consumer Finance Compass. I'm Jason Tompkins, and we'll be back soon when there's another decision that affects the consumer finance industry.